All right. Welcome, everyone. This is Kurt Varone,
And Brad Pinsky.
and we are here for another edition of File Law Roundup, this time for October 23rd of 2023. Brad, take us away.
We do have some interesting ones today. I can't wait till we get to the ketamine one, and I'm not going to make fun of anybody there. It's an interesting case. But anyway, okay, so let's start in Iowa. I have questions but this is just a lawsuit. We have an Iowa firefighter. He was hurt while responding in fire apparatus to a call. The firefighter, because of his injuries, I'll explain it, is suing the vehicle owner and the driver. I think, are they separate individuals? In many states, like New York, the owner is responsible for anything that happens with the vehicle, right? Because they're the insured ones. In any event, here, he collided with a field sprayer. The driver of the farm equipment actually pled guilty, which is going to be some evidence of negligence, right? And well, I'm saying New York's rule, but normally when you plead guilty to a crime or a violation or a driving infraction, it's some evidence of your negligence. He pled guilty to operating while intoxicated and leaving the scene of an accident. Now, that doesn't mean that he was negligent in driving, but this is got to get settled, right? And the problem is you've got an owner here who owns the field sprayer, who's not the operator, who is liable by virtue of he owns the vehicle. But here's really what I thought was interesting. So Iowa, I don't know the law, Kurt. I don't know if you know the law in Iowa, but we have something called the firefighters rule, which typically says firefighters, while in the performance of their duties, cannot sue those who cause them injury. Now, a lot of states like New York, this is gone. So some states will have it, some don't. It's a very unfair rule where sorry, I got a dog barking in the background, where the owner of the vehicle, wasn't liable for anything, and they then have to pay now for somebody's negligence. But hey, you gave your vehicle, in this case, farm equipment somewhere. But here, the firefighter, let me back up one. The firefighter rule says that firefighters should have an expectation of getting injured. This is my words, because they're doing something with a heightened danger. And because of the heightened danger, we're not going to allow them to sue the property owners, et cetera. The states like New York, who have gotten rid of the firefighter rule, say, wait a minute, there's one thing when, a firefighter just comes onto your property and gets injured as part of the fire, but where you had a dangerous condition that you should have known, where you've done something negligent here, like, caused an injury with your vehicle, where things are your fault as owner, property owner, vehicle owner, then they do get to sue you. So I'm assuming, I don't know, in Iowa, they have actually gotten rid of the firefighter rule and allow you to sue. On the other hand, for all I know, this will get dismissed because the firefighter rule is still here.
Yeah, the firefighter rule in some states is very broad, so it covers just about everything. But in most states, they have exceptions. I think you mentioned that in most states, they have an exception. And there's a number of exceptions. Some states, don't ask me why I know all this stuff about the firemen's. You got to get a license. I had to study it to write my book, believe it or not. But one of the common exceptions is it applies to someone who causes the reason for the alarm. Okay, so that could be Mrs. Smith. She has a fire in her house, so you can't sue Mrs. Smith. Okay,
that's
but
wrong.
You could sue her neighbor who didn't cause the alarm or other things like that. That's some states have an exception like that. Other states say it's property related, so that when you go to the property where the incident happened, you can't sue anyone if it happens at the property. But here they weren't at the property. So that would be, so again, there's a zillion different exceptions to the firefighter rule. I guess that's the proper term for it today, or emergency responder rule, whatever they want to call it. It used to be called the fireman's rule. But there are a number of exceptions to it. It's interesting. I didn't even think about it from that perspective when I read the case. Many times when someone has committed a criminal act, I mean, every state that I'm aware of that has a firefighter rule, a typical exception is where someone commits a criminal act. And that's usually considered to be so outrageous that they shouldn't get the benefit of the firefighters rule. So I'm thinking it's going to go forward. There's a couple of, it looks like big corporations. There's 3 different corporations that were named as co-defendants and their insurance companies. So they were insured. I'm betting on some sort of a settlement. But I think it's sad, this the kid who got hurt appears to be a volunteer, and they actually did a GoFundMe for him. And I was looking at it the other day. It only, they only raised about $6,000. So certainly, and I guess he had some pretty substantial injuries. So, certainly anybody who's inclined to donate, that might be a good, good cause. I left a link on the GoFundMe page on the blog. So.
And I think all our viewers should understand that in some sense, there should be more lawsuits because compensation may give you salary, but if you're a volunteer, you get whatever the daily benefits are, but you don't get pain and suffering. I'm not aware of any state that gives you pain and suffering as part of compensation. Right. There are things you don't necessarily, your spouse may not get loss in consortium. You don't get loss of enjoyment of all the things I could do in the future because I can't walk properly anymore. There's a lot of things you don't get, which you're not compensated for with the, volunteer firefighters compensation. So obliterating the fireman's rule, which I'm very much in favor of, is why should we be any less protected than a member of the public when they're injured? Right. So if you're a firefighter and you're injured because of somebody's negligence, then I think you should be able to be compensated over and above what you get for comp. And, comp will reduce what they'll have to pay you, but that's okay.
Well, he may not even get comp. I know maybe in New York you get comp. We don't get comp in Rhode Island. So yeah, I know. So it's up to each department to have, like in our department, we have VFIS disability insurance, but that's capped. There's a limit. Wow. So yeah, so there is no comp. So especially in a state that doesn't provide that kind of a benefit, and I can almost see if you're getting comp, that is at least something. But where you don't have comp. And I'm not sure they'd be doing a GoFundMe if he had comp. I don't know. Who knows? But.
Okay. But at least, firefighters should understand you should at least look into whether you have a basis to sue somebody, whether you're prohibited, allowed, because most times we get injured, we're like, it's part of the job, but where it's somebody's fault and the law allows us to sue, we should take advantage, of that if
sure. Justified. Not to belabor the point, but the fire department should encourage that because the fire department has a right to be reimbursed for any of the expenses. So if the fire department or even the workers' comp insurer paid for medical bills, paid for disability insurance, et cetera, they can get basically stand in the shoes of the person who could sue and recover their expenses as well.
Okay. So, okay, a real quick one. We have a former fire chief. He has filed a grievance because he's failed to be reinstated to a prior rank. And I look at this kind of as a breach of contract action. I'm kind of skeptical of it, but he reported it, so we'll talk about it. So we're in Florida. We have a former fire chief who is the fire chief, I believe, and he wants to be reinstated back to battalion chief. He was the fire chief. This is in St. Johns County, and he decided to resign. Now, once you resign, pretty much you're waiving most of your rights, but he decided to resign earlier the month. And he was told by the interim county administrator that he would be allowed to return to his previous position as battalion chief. So he filed a grievance saying, I haven't been. There's a lot of things we don't know. Was he promised? Did he resign first and then was he told, which in case he's done, or was he told and then he agreed to resign based on that promise? I don't know the answers to those. We'll see more on this, I'm sure. My point to all the viewers is, one, get everything in writing. Words mean almost nothing. And two, if you resign, you give up pretty much, unless there's coercion or duress that force your resignation. If you resign, you're pretty much always giving up your rights. So, okay. I don't think we need to do much more on that. No. This one, I think I need a little help with. And I've been reading the case. It's interesting. So let's go to Massachusetts. And we have a lawsuit based on a violation of a state law A fire department runs
and federal law
and federal law
and federal law.
Yep. And I got to say, I don't know if you have, I've never seen this federal law come into play on some things like that. And I just haven't, partly because firefighters, police officers were in sensitive positions. So these types of background checks, I think, are appropriate, not necessarily all the information we may or may or not get. I will note in some states like New York, you can't do real background checks at all. You can't get fingerprinted DCJS, but I'll talk about that. So in any event, so basically here's what happened. And this has been going on and on and on. I think this is the third motion that's now been decided. So he was denied employment. This is a really interesting twist. He was denied employment because there was a problem with the background check. He then sues. There's been a couple of motions to dismiss. They've now come back. He's still in the game. The judge has kept him in the game. So we're, he's not out of this. He sued the contractor who performed the background check, I think, for getting information or transmitting information which is either wrong or inappropriate under the statute. I'm not totally sure. The big twist on this, judge didn't care, and I understand why, is he was then offered the job later on and refused it, declined it. If I'm his lawyer, I'm slapping him. Like, what are you doing? Declining it. Either way, because I would argue he's then cut off his damages right there. Whether it's
certainly mitigate. You have an obligation to mitigate damages, and once you turn the job down, that's really where your damages are going to end.
Right. And it really is kind of the, yes, he gets damages beforehand, right? If he won, but it raises a question to me. And if this went to a jury's going to think about this heavily. It raises a question to me. Did you really want the job? Would you have accepted it back then if you took it? Why wouldn't you accept it now? You got what you wanted. So in any event, the suit is still going forward. It's important to note that what he was, and I'm going to talk about this, what with the federal laws, I think it's a Federal Fair Debt and Collection Act, or Federal
Fair Credit Reporting Act. It's different than than the Fair Debt Collection Practice. And
a lot of civil service positions will ask you about bankruptcy. They might also ask you, I've seen some ask about gambling, which is probably inappropriate, but right, all wondering whether you're a risk for theft of people's homes. I think it relates. Right. I do. I think it relates, but apparently,
that act goes beyond just looking at your credit report. It goes back, and it's very broad in that for virtually any sort of background check, it is implicated, and anyone who's doing a background check has to be mindful of certain parts of that law.
So here's my question. What was it? Because I don't see it in the read up, and I'm trying to find it in the case, which is in front of me. What was it that they accidentally, or what did they say?
I didn't want to get into the details of it because there's some
talk about lying about his residence,
whether or not he was arrested. Was it really an arrest? Was it not an arrest? So that was one. Did he have his EMT? Did he not have his EMT? There was some factual questions, and I think part of the defense of the background check company was that they accurately stated the facts.
What they found in the record.
Right. But there were some nuances in there. And I guess what the court basically said is there's enough factual allegations here that it's got to go before a fact finder, whether judge or jury, but somebody's got to determine the facts. But the factual allegations are enough to get it beyond the motion to dismiss.
Yeah. And I was surprised a little bit about the arrest part. Federally, and I'm going to guess most states, you can't ask, have you ever been arrested? You can ask if you have a pending arrest, but you can't ask, have you ever been arrested? So reporting arrests is shocking to me at all because you're presumed innocent. And if it didn't dispose in a conviction or a plea, it shouldn't be reported at all. But
there's typically exceptions, and very often law enforcement and fire are two of the exceptions. I didn't delve into Massachusetts law on that issue, but very often police and fire, they do have a right to know that. Not every state, but some states there is a different level of scrutiny that's applied to criminal records. So I think that may have come into play, but I wanted to include the entire paragraph 9 there from the Massachusetts law, so folks can get a sense for how some states, now Massachusetts, New York, California, you guys are all sort of in that very liberal, personal protection mindset. But most states are not anywhere near as strict as those 3 states.
Yeah, and part of this even says you can't discriminate against any person for reason of his or her failure to furnish such information.
Right.
I thought that was interesting. If you ask a valid question, at least under state law, and you say, no, I'm not going to do it, and how do you not discriminate? But I'm sure there's a lot more to that than I'm
there is, and that was actually an issue in the case. That will be an issue in the case because there was some questions about him. He was asked about his EMT and he didn't answer. And they took that to be he didn't have his EMT, which was inaccurate. But he didn't, again, there's some things that you do have to answer, things you don't, but a lot of nuances in this case. And it's going to have to, now the judge basically said it's going to have to go to a trial, or at least for further proceedings. It's not going to be dismissed at this point.
Okay, I love this next case. I love it because it's so interesting for so many reasons. And of course, you start off man bites dog, right?
Can we start with that?
With the humor of it.
Because but somebody reached out to me and says, where did the man bite the dog? I know it, and it's a metaphor. And I actually, I think it was on LinkedIn or Facebook, I posted a wiki to the explanation for man bites dog, but it's a journalistic kind of thing where the typical thing that happens is a dog bites man. Dog bites man, that's not news. Okay. Man bites dog, that's news.
That's news.
Okay. So that was sort of the theme I was going for there. And somebody was like, where did the man bite the dog? I missed it.
With no offense to the person, I missed the humor of it. But here we have, so the man, by the way, who did not bite the dog, or was not, nor was he bitten by anybody that we know of. The man died. A daughter of the man is suing, and I'll explain why. But suing EMS, firefighters, the police, for the failure to administer ketamine. Now, he died, if I have it right, it's a little hard to figure out. He died on scene, but let me explain what I do know. Please fill in the blanks. What I do know is this person allegedly, because I have a very different take on this suit. This person allegedly is having a episode, which the lawsuit claims the medics on scene should have, and I'm using this term in quotes because this is what they say, diagnosed the man with a extreme mental/medical condition, right? And they said that they delayed transportation and, more importantly, treatment by not administering ketamine, and they joked about him and didn't take him seriously. Let's push off the joking for a moment, because there are body cameras here, and the cameras are going to show what they show. And I don't care whether they're body cameras or not. If you're a police officer, if you're a firefighter, if you're a public servant, if you are walking down the street and you don't think you are being recorded 6 ways to Sunday today, and you act like you're not being recorded, you're nuts. So always act like you're being recorded, and then hopefully you won't do anything which you may or may not later regret. We're not saying the firefighters are wrong or the police are wrong or anybody's wrong. I'm just saying act like you're being recorded. You won't regret anything you say. So here, I want to just chime in to say they said you should have administered ketamine and you failed, but you didn't do so because you failed to diagnose him properly. Now, I just want to say this. There's a big question. The practice of medicine is defined in, I will bet, most states, definitely New York, but I will bet most states, as the diagnosis or treatment of a medical condition. In New York, and I haven't looked other places, but this is why I bring this up. In New York, the courts have tried to answer the question of whether EMTs and paramedics on the phone with the doctor or not on the phone with the doctor have a patient confidentiality, patient doctor or patient EMT confidentiality. And the courts have said, listen, the only way to answer whether there's a patient/EMT confidentiality is if they are practicing medicine. And in New York, courts are split. This is why I love this issue. The courts have said, there's like 2 and 2 on each side. Not a lot of cases, but 2 and 2 have said paramedics and EMTs do not diagnose. They treat, but they do not diagnose. They simply look for signs and symptoms and respond accordingly.
What is that? Isn't that diagnosing?
Well, I got to tell you, I actually agree with that side of things. And
well, I can understand that because you want to get to the right answer. But when you really, what is diagnosing? Diagnosing is looking at symptoms and saying, oh, this person has whatever, they're having a heart attack. That's diagnosing.
Except with EMS, let's say we go to somebody, he's got a gap in the P wave, and we're going to say first degree AV block, whatever, right? That's pretty good of me. It's my little bit I know about EKG. No, so we're going to say, well, okay, you've got, some condition. We don't do that. What we actually say is when we see this blip or lack of blip on an EKG, on a 12 lead, right, we provide this. So if you're bradycardic, we provide this. If you're tachycardic, if you're SVT, we provide this. We're not diagnosing the condition. We are treating, right? But we're just responding to the signs and symptoms is on the one argument side. The other argument side is exactly what you said. And again, courts are split, but that is exactly this lawsuit, because when somebody says you failed to diagnose me, wait a minute, that's not the proper, may not be the proper phrase in the lawsuit. And I hope the lawyers, or don't hope the lawyers, whatever, looked at what actually EMTs in that state and paramedics in that state are deemed to do or not do. Are they practicing medicine so they diagnose, or you didn't follow the protocol? The better term here would have been you failed to follow the protocol, because there's no discretion, right? Not a discretionary act. There's probably no discretion with failure to follow the protocol, no government immunity. Therefore, very important standard here. Again, this is just a lawsuit, right? We are not anywhere in court yet. It's just a lawsuit. But they basically then threw on, you didn't take him seriously. You were joking about it. I haven't seen the body. Is the body cam footage not public yet?
I haven't seen it, but I think one of the reasons this case is being filed 2 years into it is because they only recently were able to get the body cam.
Right. But it didn't appear. I didn't see it posted anywhere. And
I didn't see it.
So look, the body cam footage is going to be easily accessible. I'm surprised it took them 2 years. Laws have come a long way in 2 years.
There's a reason why.
Yeah. Oops. It didn't turn on. But
you didn't really say that. Did you just say that? I can't.
Yeah, no. And as you make the point of saying, right, I'm re-summarizing, but you really should make sure that you're acting like you're on video, whether you are or aren't. Just assume somebody's recording you or you're being listened to, whatever it is, and act appropriately. Somebody's worst day, and I'm not saying they did this. I'm not saying they did this. Don't be offended if you're the EMTs and firefighters watching. I'm not suggesting you did what they said, but generally speaking, if we don't laugh at somebody's condition. You want to laugh after when you get back to the firehouse? By all means, right? That's how we release stress and whatever. But in front of somebody's family or to anybody else in public, no way. Because this is what happens, right? And I think you said a while ago, and it was a good point. It was the first impression here. When you upset somebody, they tend to sue you. When you just apologize, I think you said this a week or 2 weeks ago, when you just come forward and say, hey, I'm sorry or whatever, and you treat them with compassion, you treat them with understanding, maybe they don't want to sue you, but you piss them off, guess what the reaction is going to be?
You make them wait 2 years to get the video, which suggests that you're trying to hide something. There's so many aspects to this, though. I think your typical approach in a case like this is also one of causation. How do you prove that the failure to administer ketamine is actually what caused him to pass away? You're going to need expert testimony.
How did he pass away? I didn't see it. Did you see it in any? I read I can't find.
They're saying excited delirium, but that's a diagnosis, and whether or not it's accurate or not, that'll be debated as well. But whether or not the administration of ketamine would have changed it is a whole different thing. And I do want to point out it's a little bit frustrating. And there was another lawsuit on a ketamine related death in South Carolina. I was going to post the next day, and I said I don't want to make this ketamine week, with 2 or 3 or 4 cases on ketamine. But I've got 19 cases of ketamine related deaths, including criminal charges. Again, this case up in Aurora, Colorado, where firefighters are facing criminal charges for administering ketamine, where state legislatures have actually considered banning ketamine. So there's a lot of negativity about using ketamine. And here we have this lawsuit saying you're negligent for not administering ketamine.
Right.
So, it's like, was it the Goldilocks and the Three Bears? It's too hot. The pudding's too hot. The pudding's not hot enough. Got to find it just right here. But frustrating issue here for everyone concerned. The videos, our firefighters have got to understand when we respond with the police, and most police today have body cams, which they didn't back when I was a young firefighter. That was not an issue, but there is today. When you couple responding with the police with a fatality or an arrest or any of the other things that seem to be in the news today, you can count on attorneys watching every single body cam. If there was 20 police officers on the scene, they're going to watch 20 different body cams, literally frame by frame, looking for something that you either say or do for which they can hold you liable. You have to understand that. It's not 1980, it's not 1990, it's not 2000 that attorneys are doing this. And we've got to realize when we are going to assist the police or the police come to assist us and they have body cams, it's not just that it might be recorded. It's going to be that they're going to look at that recording frame by frame, looking for something to hang their liability hat on. And we've got to recognize that. We got to make folks aware of it.
And I think people also need to understand, this isn't September 11th or September 12th of 01 where everyone loves the fire service. It's not what it is. If everyone loved the fire service, then when a firefighter raped somebody, when a firefighter hit somebody, when a firefighter did anything, it wouldn't start with firefighter does, right? The news headlines wouldn't start with the word firefighter. We are everyone's best friends until we're not. Give them a reason not to. Give them a reason to say you breached their public trust, and they will take you to task. It's a totally different topic, but same thing. Watching people in front of somebody's structure fire take pictures of themselves, take pictures or smiling or pose. Or,
hey, look at me.
Yeah, I'm in front of somebody's worst day of their life as they lose everything they own, right? I mean, you got to be kidding me. But we do that. Why? Because we're stupid. We've done stupid things, and I've been there. I was young. But we've got to remember that the public we have a public trust. And when you are perceived to breach that trust, they're going to go after you. The police have learned that. We need to learn that.
Yeah.
So let's go to Rhode Island.
All right.
Have you ever been to Rhode Island?
Yeah, a couple of times. About I'm coming up on my 67th year here. So we got an interesting case, and believe it or not, I know everybody involved here. So
I believe it.
Right from plaintiff's counsel, defense counsel, the fire chief, the union. So
I didn't know if you had to be neutral with this. So because you got to,
I do, somewhere. and I will anyway. I will anyway. But what we've got is we have a local, like it's a small fire department, and what's been happening here in Rhode Island, really for the first time, is we're getting a lot of lateral movement from Fire Department A to Fire Department B, with typically smaller fire departments almost serving as a feeder or training ground for the bigger departments. So folks start out in a small department, move to a bigger department.
Happens here too.
And I guess it's always happened for, to some extent, but it's really happening a lot now. And Tiverton is one of those departments that has been going through people, and they're finding themselves very shorthanded. It's cost them a lot to hire people, and then to watch them go on to Providence or Warwick or Cranston or some of the other bigger departments. So it's frustrating. I get it on that level. The union is concerned as well, because they're short people that's requiring them to work overtime. Now, every firefighter loves overtime. That's, it's like, I joke about, it's like cocaine. Overtime is like cocaine to firefighters. You'll forsake your family for it. It's got all the classics of an addiction. Okay. But, and you'll screw your brother or sister for it, and if you can
I don't think you can say that on YouTube. Yeah.
Well, if you can weasel away, to get it. Yeah. We got to watch what we say on YouTube, but at any rate. Okay. So, we love we love overtime, but it's so excessive that folks are getting forced to work the extra hours, and they want to go home. I mean, you work 4 or 5 days in a row, you got to go home. So bottom line is the union's been raising the alarm about that in social media. That prompted the city to come out with a new social media policy. They had some rules that they date back probably to the 70s or 80s, but they were kind of outdated in some of the language that they used. And so the bottom line is they come out with a new social media policy, and then the day the social media policy came out, they notified the union's executive board that they were going to be called in for investigation. And so the union went to a good friend of mine, Ed Roy, who's does a lot of labor litigation, and he took it right to U.S. District Court here in Rhode Island, and sought an injunction both against the further investigation, the disciplinary investigation, as well as he wanted basically a declaratory judgment that the new social media policy violated the First Amendment. And from my look at it, he's going to win both of those. He's absolutely going to win both. Now the city or the fire department, from what I understand, and I don't know if their legal counsel was involved in the drafting of the social media policy. I hope he was, but I don't know. But there's some nuances that are necessary when it comes to First Amendment law. And if you just look at other people's, who just look at old versions of social media policies or even rule books, you're probably going to run afoul of that. And you and I study it with our friend Chip. We know what's got to be in a social media policy and what you absolutely can't have in it. And this had some admittedly nuanced things in it, but you just can't prohibit people from speaking on matters of public concern as private citizens. They have a First Amendment right to speak on matters of public concern as a private citizen. And again, as long as they're not causing actual harm to the mission and functions of the department, not to get overly technical with the language.
Disruption in the fire department, all that.
Right.
Yeah.
So you've got to have some nuance in that language, and that social media policy did not. I am a little bit surprised, and I did not talk to Ed about this, but personally, I would have fired both barrels at them, because there's another, they went after it on First Amendment. Anybody wants to look at the complaint, you can look at the complaint. Very well done on First Amendment law. But I think there's also a concerted activity aspect, the right of employees to work together for their mutual protection, that I would have alleged as well, that you not only violated the First Amendment rights of the employees, but you also violated Rhode Island state collective bargaining law, which gives firefighters the right to work together. In hindsight, I don't think it's necessary to do that, because I think he's going to win hands down on the First Amendment part. But I think I would maybe I'm a little bit more cautious than Ed. I would have blown both barrels on both the First Amendment as well as concerted activity.
Yeah, and let's focus on things, because there's always two questions, right? Are you speaking as and there could be three if you go on Chip's side of things, right? But there are two main issues. Are you speaking as a member of the public, or are you speaking as an employee? If you're deemed to be speaking as an employee, your speech is not protected generally. Right. Okay. But here, then you get to, is it a matter of public concern? Mm-hmm. And, they have talked about staffing issues, manpower issues, and overall readiness. Mm-hmm. Those, and this is not the first case, had the drafters of the social media policy looked, those issues, certainly staffing and manpower, have been in a plethora of fire service First Amendment cases, and they are absolutely matters of public concern. How many firefighters are you paying? How many are going to respond? Minimum manpower. All these things are undoubtedly, irrefutably now, matters of public concern. So you're going to lose on the second. So then to gamble, because this is how I look at it. okay, you're willing to take a risk, or you're just kind of ignorant of the law that you say you can't speak about certain things that, look, is too general, that happen to encompass staffing, right? Matters of public concern. What you're doing then is you know you're losing on that. What you're banking on is that, oh, no person who's a member of the department, no employee will ever be deemed to be acting as a citizen. That's a huge risk, right? I mean, that I wouldn't play that game.
No, you can't. You can't. And especially in a collective bargaining environment where folks are acting in their capacity, not as employees, but as members of the executive board of the union.
Yeah.
That is not the same as acting in your capacity as a firefighter. There's a clear distinction and there's a crossover. And you can't put a gag order on knowledge of things that come out of the fire department. What can the union talk about? If they can't talk about those important things, it inhibits their ability to represent their members.
And getting, you were referring NLRA, NLRB, when you talk about, right, two employees have the right anywhere to talk about employee issues, and you cannot stop two people from texting or posting in a group chat or on Facebook or in a messaging, the firefighters of so-and-so fire department group. You cannot stop two people from talking about employer issues. So I think is great. I think you were dead on right.
So long as it does not, it can't damage the organization. There's certain limits on the collective bargaining part of that, but you can't tarnish the organization's reputation. You can't do damage the brand, I guess you could say. Right. Now, I don't know how that, when you work for Coca-Cola, damaging the brand is one thing. It's a little bit more difficult to translate that concept over on the public side. But you can't damage the reputation of the brand, and you can't disparage the customer. Okay. Short of that, as long as it's work related, it's and that's tough. And as somebody who, was a chief in an organization, a deputy chief in an organization, not in the union, people are going to say bad things, that's, lump it. I mean, right. or don't take the promotion, but that's the way it goes.
You cannot tell employees that they cannot talk together about work conditions, whether it's online or in the station. You cannot do that. You can tell them they can't go into the supermarket and start bitching about things, right? But you have to allow them a place to do it. And you can't punish them for collectively talking about it. And we do that all the time.
Very narrow area where you can restrict them, like for something that's under investigation. Okay, right. Fine. You got a fatal fire that's under investigation or whatever. Fine. Right. We can say, okay, you're not to discuss that. That's fine. You can, there are very, very narrow, nuanced limitations on it. But to have
to say blanket, they can't talk about staffing,
talk about anything related to the fire department in social media is a problem.
And look, every paid firefighter knows. What comes with the good comes with the bad. We want minimum staffing. What is it? 1710, 1720. We want minimum staffing. Well, guess what comes with minimum staffing? Mandated overtime. So, you get two together. Oh, we're short staffed. We're this, we're that. You want minimum staffing, which we should have, right? But it comes together. But I kind of want to end with this, because everyone will say, well, what can we say in a social media policy? And, you teach what, a 2 or 4, 8-hour course on developing social media, right? So it's not a quick answer, but my minimum answer is simple. Nothing discriminatory, hateful, racist, sexist, all the isms and ists and antis that you can't discriminate against, all that. You can't bully, you can't harass, that should be what you can't do online. Going beyond that, you are rolling the dice. And if you are not, I'm speaking to the lawyers, I'm speaking to the union presidents, I'm speaking to the chiefs who watch us, the many, many big city chiefs who watch us, and saying, if you are just copying someone's social media policy that's even 6 months old, it has not met the newest cases. And you and I constantly, I would say once every 4 or 5 months, are looking at some of these cases, we're like, wow, this judge either got it right or this judge got it wrong, or, whatever. But you are rolling the dice. The moment you tell your employees they can't say bad things about the department.
Called a prior restraint. Okay, it's called a prior restraint, and there's many. In fact, one of the cases I like to use in class is one out of Washington D.C. It's the D.C. bumper sticker case.
Yeah.
The court made it crystal clear that prior restraint, when you try to restrain somebody from speaking before they speak, it comes to the court with a presumption that it's invalid. Okay, now that was a district court case.
I'd use that case.
Yeah, I use it. I use it a lot, but it says that when you try to stop someone from talking before they say something, basically it comes to the court with a presumption that it violates the First Amendment. It's up to the employer to say that this fits into one of the exceptions.
Right. So people just do not copy. Maybe I'll end with this. I keep ending with something. I was doing a human resource manual for somebody, employee manual, and it's, 400 pages of, federal and state laws. And I'm looking at the other one. I'm like, what that they came to me with, I said, where did you get this? Oh, we copied it from so-and-so. We copied it from so-and-so. We copied it from so-and-so. I'm like, that is just literally playing with fire. Do not just copy. Right. And don't go to your real estate lawyer. Don't go to this stuff is so complicated that unless you follow this like you do, like we do on a day-by-day basis, you are crazy. You are going to violate someone's First Amendment rights. And you don't want to be there because we know there are those First Amendment advocates who will come right after you. And when a union member feels that you have discriminated against them or shut their ability to speak on something they should be able to speak on, you are going to get sued, and this comes with damages. Don't do it. Don't just trust your local whoever. Get somebody knowledgeable to write these things. And my last word of advice for everybody is a legal phrase. It's Latin. You might not understand it. Suck it up, buttercup. It's people are going to say mean things about you. Oh, the freak well, right? I mean, that just happened. So if you don't want your union to say bad things about you, then give them everything they want. Right? I mean, that's really it. And you're not going to do that. So expect they're going to say bad things about you and suck it up. It's just it comes with doing business, but trying to prohibit them from speaking about important issues is not the way to do it.
All right. Well, that wraps us up for another week of File Law Roundup. Brad, we'll see you again next week. All right.